Good evening, everyone. So we are continuing our discussion of company law. Yesterday, we started discussion of the law itself, and we actually discussed session 1 right up to the middle of session 7. And we, among other things, emphasize that the law guarantees the right of every person to form a company. And that means that if one person can form a company, so long as he or she is able to satisfy other requirements of the law. And again, we also discuss the various types of companies which are recognized under our Companies Act, Act 992. We said that we have company limited by shares, company limited by guarantee, we have unlimited company, and then we have external company. Now, with respect to company limited by shares, we made the point that the liability of members, that is how far members can be made to pay debts of the company, does not go beyond how much money they have actually paid, or how much money they are supposed to pay in respect of shares that have been issued to them. For that matter, where you have unpaid liability on your shares, should the company, for example, run into difficulties and is being liquidated, you could be asked to come and pay the unpaid value regarding the shares that were issued to you. However, once you have paid that, nobody can ask you to make any more payment, even if the monies realized are not enough to pay the debts and liability of the company, because you are a member of a company limited by shares. Your liability does not go beyond the amount of money you have paid in respect of your shares, or you ought to pay in respect of your shares. And then we also said that where the company is a company limited by guarantee, what it means is that members have made undertaking regarding how much money they intend to pay towards meeting the debts and liability of the company, should that become necessary at some point in the life of the company. And we noted that it is not actual payment they are making, it is undertaking, right? It's an undertaking that they have made, that in the event of the company being wind up and we have the company has got debts to satisfy, this is how much I am prepared to pay. Now, we noted that once you have, for example, assuming the company is being wind up and you are called upon to come and pay how much you undertook to pay, once you pay that, even if there are still other debts and liabilities to be met, that will be it. Nobody can actually push you to pay more than what you initially undertook to pay. Then again, we talk about unlimited company. You said that unlimited company, as the name suggests, members do not have any limit on their liability. And more or less, their liability situation is not different from that of a sole proprietorship, as it were. And we made the point that usually unlimited liability company is used for maybe professional services, like maybe doctors, lawyers, accountants, and so on. And we noted that they usually have insurance policy to cover any negligence suit which they may have to face and all that. And again, we also cited the securitization arrangement, where SPV, special purpose vehicle, for example, it is set up for just a very narrow purpose. And for that matter, the risk that is involved in its activities are virtually non-existent. And for that matter, if it has unlimited liability, it's possible, because actually it's not likely to have any significant liability, as it were. Then we also talk about external company, and we said that external company is a company which was incorporated or registered outside Ghana, but has established a special established place of what business in Ghana. Yeah, so that is the external company. So that is where we actually ended. And we said that with respect to external company, the law has referred us back to Section 329, and we went there to look at it. So we want to continue that discussion. And so the other point to note is that, maybe let me add this. If you have unlimited company, it is still required that it is registered with shares. And in fact, if you look at Section 7, subsection 3, that is what is telling us that if you have a company limited by shares, an unlimited company, for purposes of incorporation, it must be registered with shares. In other words, of course, for company limited by shares, we understand, but I'm sure you'll be wondering, if it is an unlimited company, why should it be registered with shares? Well, of course, for purposes of also sharing profit as well. Because if you have shares, then shares are profit to be shared in proportion to the number of shares that you have and all that. The only difference is that for unlimited liability, with respect to liability, it's not limited to the amount of shares that you have. So that is the only exception. Otherwise, Section 7, subsection 3 emphasize that both company limited by shares and unlimited company must be incorporated or registered with shares. So let's keep that in mind. Now we come to another important aspect of the typology, or the kinds of companies that the kinds of companies that we have. Okay, I'm teaching online. Let me call you. The kind of companies that we have. So if you look at Section 7, subsection 4, right? Section 7, subsection 4, the point is made that a company of a type specified in subsection 1, that is the types that we've gone through, that is the company limited by shares, by guarantee, unlimited company, external company, may be a private company or a public company. So that is another important point that we should keep in mind, that we have public company and then we have private company. And the public company or private company may have one of the permutations that we have seen, either with respect to shares or the other type. So we are going to, first of all, get a clear distinction. What makes a company a private company? And what makes a company a public company? Now, the reader, can you read Section 7, subsection 5 for us? Anybody?
Okay. So I want to.
Yeah, go ahead.
Yeah, I want to volunteer. Okay. So Section 7, subsection 4. A company of a type specified in subsection 1.
No, I said subsection 5, 4, 5.
Oh, okay, sorry. Okay. So 7, subsection 5. Okay.
Yeah.
5. A private company other than a company limited by guarantee is a company which, by virtue of its constitution, A, restricts the right to transfer the shares of the company, if any. B, limits the total number of the members and debenture holders to 50, not including persons who are genuinely in the employment of the company, and persons who, having been formally in the employment of the company, were while in that employment and have continued after the determination of that employment to be members or debenture holders of the company. C, prohibit
Okay, you've lost him, but that is fine. Good. So,
T.
yeah. I read that. It's all right. Thank you. It's all right. Thank you. Thank you. Yeah. So, one thing I want us to pay attention to is that if you look at the section 7, subsection 5, which provides the distinction between a private company and public company. First and foremost, the law tells us that it is the constitution of a company which will specify whether it is private company. So let's keep that in mind. So, which by virtue of its constitution, okay? So, the constitution of the company will specify whether it's a private company. So that is one thing which we take from the 5 before we look at the details. Now, how does the constitution of the company indicate that it is a private company? Well, the constitution will provide for certain restrictions. And because of those restrictions, the law says that the company is a private company. So, you're saying, one, shareholders cannot transfer shares at will. You know, if you're a member of a public company, you can easily transfer your share to anyone who is willing to buy your shares. But private company, there's a restriction on transferability of shares. So that is one. And two, there's a restriction on membership. Membership cannot exceed 50. So private company membership cannot exceed 50. And then the law is telling us that in trying to compute this 50, we disregard certain persons. And those persons who are disregarded in trying to arrive at the 50 are those who are employees of the company. So it is possible later on when we are discussing capital maintenance doctrine, the company for good reason may create a scheme to enable its employees to acquire shares so that the employees will feel motivated that they have a stake in the company. And once they have a stake in the company, they will work very hard. So the company can put in place an arrangement in which employees are assisted to have shares. So once you get the share in a company limited by shares, you are a member of the company. However, section 7, subsection 5, paragraph B is saying that because you are an employee and have become a member by reason of you having acquired shares, you will not count you as the 50 who should be the maximum members of membership of the company. And two, if you were like an employee of the company and while you were an employee, you acquire shares and for that matter, you became like a member. And now you are no longer working for the company, but you still have your shares. You will not be included in trying to find out whether the company has actually met the 50 membership. So let's keep that in mind. Another indicator which the constitution of the company will provide for us to know that the company is a private company is that the constitution would prohibit the company from making an invitation to the public to acquire shares or debentures of the company. This is very important. Later on, when we discuss corporate finance, there's something called invitation to the public. Now, invitation to the public is calling upon members of the public who are interested in acquiring shares or lending money to the company to come forward and do that. Not too long ago, MTN, when they wanted to do their initial public offering, I remember they did a massive advertisement and all that. They packaged information about their company and sought to entice as many as they could get to come and buy their shares. So that is an example of invitation to the public. Now, a private company by law is prohibited from making any such invitation. So a private company can, for example, not rule out advertisement to say that, please come forward and subscribe for shares. No, that is prohibited. Again, a private company is also prohibited from making invitation to the public to deposit money for fixed periods. Of course, this is even not a big deal now because no, if you are doing something like that, it's like you are trying to do some form of like a banking, and you need to become like a bank, and a private company is not allowed to do that. Now, another point which you should remember from section 7, subsection 5 is that a company limited by guarantee, right? A company limited by guarantee cannot be a private company. Let's keep that in mind. So company limited by guarantee cannot be a private company by definition. And that is why 5 is saying that a private company other than a company limited by guarantee because all these things you've talked about, all the restrictions and prohibitions, they're actually relevant where you have shares. If the company does not have shares, those restrictions are actually useless, isn't it? They don't apply. Good. Now, the question will arise, how do we know a public company then? Well, the lawmaker has told us what a private company is and has stated that if you don't fit the criteria of a private company, then you are a public company. In other words, a public company is a company whose membership exceeds 50, a company which does not have any restriction imposed by its constitution regarding transferability of shares. Its constitution does not prohibit it from making invitations to the public to subscribe for shares or to deposit money for fixed period for interest and so on and so forth. So a public company has the reverse of the characteristics or the criteria which we have seen in section 7.5 as being applicable to private companies. And for that matter, if you look at section 7, subsection 7, it says that a company which is not a private company is a public company, except a company limited by guarantee, which has a membership of what? 50 or less. In other words, we are being told that if you put company limited by guarantee aside, any company which has got shares, and does not meet the characteristics that we have seen in section 7, subsection 5, in terms of restriction on transferability of shares, membership not exceeding 50, prohibition of invitation to the public, and so on, it is considered a public company. So let us keep that in mind. And the lawmaker wants to remove any doubt. And for that matter, section 7(a) says that a company limited by guarantee shall not, for the purposes of incorporation, be registered with shares and shall not create or issue shares. So let us keep that in mind. And of course, we've made that already, that the company limited by guarantee does not have shares. But in the case of unlimited company, as we noted, they have shares, despite the fact that the shares do not serve as a basis of liability. Unlimited companies still have shares. Any question before we move on? Okay. Right then, let's discuss company limited by guarantee a little bit more. So we want to discuss section 8, company limited by guarantee. Read it for us.
Okay, sir.
Yes.
Hello, sir.
Yes, go ahead.
Okay, so sir, so what section 7(6) is essentially trying to let them understand is that a company limited by guarantee can be private or public.
Yes, but you know, not in terms of the what do you call it, the characteristics under 7(5). So if you look at the 7, that a company which is not a private company is a public company, except a company limited by guarantee, which has a membership of what, 50 or less. And that is why I was making the point that yes, a private, company limited by guarantee can have
or less.
Can have less than 50. So if, and for that matter, the membership, we could say private. But apart from the membership, all the other things which makes a private company are not really applicable to company limited by guarantee. And the reason is that company limited by guarantee, they don't have shares, isn't it? And if you look at the other things, other criteria or other characteristics or features which define a private company in terms of section 7, subsection 5, restriction on transferability of shares, prohibition of making invitation to the public, and so on, all those things will not apply because company limited by guarantee does not have shares. So it is only the membership. It's only the membership that is relevant, yes. So that if it's less than 50, you could say that there is a private company. If it's more than 50, then it is a public company. So let's go. So can we move on?
Yes, sir.
Okay, so 8, company limited by guarantee, what is it?
8, okay. Companies limited by guarantee. 8(1). A company limited by guarantee shall not be incorporated with the object of carrying on business for the purpose of making profits, other than making profit for the furtherance of its objects.
Okay, good.
Subsection 2.
Before you go on to the 2, just a quick commentary on 8(1). So company limited by guarantee, it's not correct to say that it's not for profit, right? It makes profit, but the profit that it makes is not meant to be shared by its members, like company limited by shares. Company limited by shares, from time to time, when profits are made, dividends are supposed to be declared, and then each shareholder will get dividends in proportion to the number of shares that he or she has in the company. Company limited by guarantee, probably you have a company limited by guarantee, you're supposed to promote educational research, you're supposed to promote culture, you're supposed to take care of orphans or orphanage and things like that. And for that matter, you engage, and for that matter, and for that matter, you engage in some transactions in order to generate income for purposes of the activity that the company is doing. That is fine, because that profit you are generating is not meant to be shared by the members. It's meant to be applied for the purpose or the objective for which the company is set up. So let's continue. And that is why we notice that NGOs, for example, and then a lot of these charitable this thing, they will often adopt the company limited by guarantee vehicle as a way to do the activities. Section 8.2.
Okay, Section 8.2, where a company limited by guarantee carries on business for the purpose of making profits, other than for the furtherance of the object of the company, the officers and members of that company who are cognizant of the fact that the company is so carrying on business are jointly and severally liable for the payment and discharge of the debts and liabilities of the company incurred in carrying on that business. And the company and those officers and members are each liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the company carries on that business.
Okay, good. Now, what happens in company law, and for that matter, the Companies Act 2019, Act 992, is that often where the law will prescribe a certain rule, a certain obligation, now the law will add a sanction to it to ensure that what it has posited will be taken serious. So Section 8.1 says that company limited by guarantee is not to engage in any profit-making business for purposes of sharing the profit for the members. And that if it's to engage in business at all, it should be for the purpose of getting money to further the object or the purpose for which the company was incorporated. Now, where that is ignored and you decide to go and do any business at all, which you think will let money come, and your intention is to make more and share, there could be problems. Maybe there could be debts, there could be lawsuits and all that. Now, later on, we'll be discussing the concept of corporate personality and then the separate legal personality. When we get to section 15, we'll discuss that, but we haven't gotten that, but we discuss that in the light of Solomon and Solomon. And later to that, we'll also discuss the case of Mokwe and Kuma lifting the veil, where you ignore the fact that the company is a separate person and go after certain individuals responsible for certain wrongdoings. So this is exactly what Section 8.2 is doing. So here, despite the fact that the company limited by guarantee by reason of incorporation is a separate legal entity from the members, from the officers, the law does not want debts and liabilities which will be incurred when the company is engaging in activities for making profits not related to its object and purposes. Now, those debts will not be borne by the company. It will be borne by those officers and members who were in charge when the company actually engaged in business for purposes of making profits, not for furtherance of the objects of the company. And not only that, administrative penalty units, that is administrative fines, are also supposed to be exacted by the registrar of companies for as long as they continue to engage in business for profit making, which they are not supposed to do under the law. So let us keep that in mind. A3.
Okay. A3. The total liability of the members of a company limited by guarantee to contribute to the asset of the company in the event of the company being wound up shall not at any time be less than the amount of money specified in the application required for incorporation.
Okay, so absolutely. That is to say that at the time of incorporation, the amount of money which members undertook to pay in the event of the company being wound up, everyone will be held to that. So it will not be like you undertook to pay 10,000 and then later on you find a way to say that no, actually it's 2,000 that I'll pay. Should something go wrong? No. So that is what Section 8.3 is trying to tell us.
Hello, Doc.
Yes.
Hello, sir. Please, I have a question on Section 8.2.
8.2, okay.
So from the onset, you've been made to understand that company limited by guarantee, even though is to get some income, some inflow in the form of profit, but not to be distributed to its shareholders. Now, the 2 is saying that where a company limited by guarantee carries on business for the purpose of making profits,
yes,
other than for the preference of the purpose of make object of the company.
Yes.
Now, so it means that even though it is not meant to make profit, but when it is found that they are making profit, then there is a charge they will pay to the registrar. Is that the case?
Okay, good. The Section 8.2 is talking about 2 situations. The profits which a company limited by guarantee is permitted to do, profits meant to advance the object or the purpose of the company, to enable the company to get money to finance the activities for which it is set up. So let's say that if it's set up in order to run orphanages, you need money to maintain the facility, you need money to feed the children and all that. Now, it do not be wrong if, for example, you have a farm, you make and then you sell the produce, or you make water, right? You purify water in order to get money so that you can take care of the children in the institution and all that. So the sale you are doing, obviously you are going to make profit because you cover production costs and then there will be excess, and excess is the profit. Now that profit is not meant to be shared by the members. It's meant to be used for financing the activities of, let's say, the orphanage that the company has committed itself to run. But what A2 is prohibiting is where you are using the company limited by guarantee, to engage in all manner of activities to make money, and then the money is going to be shared. It's not going to be used completely for activities of the company. That is what is forbidden by Section 8.2. But in terms of the practical application, I appreciate the difficulty that you are having, because the question is, how do you determine whether this profit, which is being made, is going to be used to apply for the objects of the company or not? Well, my answer will probably be that it's not so much about the making of the profits, but as to the relationship between the transactions you are doing to make the profit and then what the company limited by guarantee is doing. For example, if you have a company limited by guarantee to be concerned about, let's say, the environment, and you end up maybe doing some other activities not related to the environment in any way, and you tell us that because you want to make money to finance activities of the company, it may be difficult for us, for the court to actually agree, because it's unrelated. But if you are doing the very activity, right, the very activity for which the company was registered, and through that, money comes and all that, and then the money is applied further towards the objects of the company, then that is permissible. So let's take, I think if look at that. So let's look at the, so if you have a company limited by guarantee, can it ever be changed to company limited by, I mean, if you have a company limited by shares, can it become company limited by guarantee? You register the company with shares. Maybe at some point, your objectives have changed. You want to make a company limited by guarantee. Is that permissible? So let's look at section 9.
Okay, so section 9, subsection 1. A company limited by shares may be converted into a company limited by guarantee if A, the liability on any of its shares is fully paid, B, all the members agree in writing to the conversion and to the voluntary surrender to the company for cancellation of the shares held by them immediately before the conversion. A new constitution appropriate to a company limited by guarantee is adopted by the company pursuant to section 30. And D, a member agrees or the members agree in writing to contribute to the assets of the company in the event of the company being wound up to an amount of money not less than that prescribed by subsection 3 of section 8.
Okay, now, before you look at the other practical procedure, so what section 9 is telling us is that it is permissible if you had a company initially registered as a company limited by shares, and the members have shares, you want to become company limited by guarantee, it's permissible. However, you must actually put away those features which are peculiar to company limited by shares, and that is the shares themselves. But shares are supposed to represent money in the company. So before the conversion can take place, every shareholder must have fully paid for all the shares which has been issued to him or her. So you shouldn't have any unpaid liability. So that is one. And all shareholders must also agree in writing that they support conversion of the company from limited by shares to company limited by guarantee, and that they are prepared to give all their shares to the company, that is a voluntary surrender, to give all their shares to the company without demanding any payments from the company. Because don't forget that your shares in the company is your money in the company. So one will argue that once you are giving the shares, then the money which you paid should be returned to you. However, when it comes to section 9, 1, the law is that if you want the company limited by shares to become company limited by guarantee, then you must be prepared to sacrifice your shares. You must not have any debt on your shares. And again, you must be prepared to sacrifice your shares, give all the shares back to the company so that the company will cancel the shares and they will no longer exist. And of course, constitution will be adopted, which will state what you want to do as a company limited by guarantee, your objects and all that. And each member will have to do what is done in company limited by guarantee. That is to make undertaking in terms of how much money you are prepared to contribute to the assets of the company in the event of winding up. So once these things have been taken care of, then the rest is just the formalities, how you get it done. So if you look at the 8.2, the formalities, 9.2, the formalities are there. So 9.2.
Okay. Section 9.2. On delivery to the registrar for registration of a statutory declaration by a director and the company secretary, confirming that the condition of subsection 1 have been complied with, the registrar shall issue a new certificate of incorporation to the effect that the company is limited by guarantee.
So
from the date stated.
Okay, go ahead. All right, go ahead. Continue.
From the date stated in the certificate, the company is converted into a company limited by guarantee. B, the shares in the company shall be validly surrendered and cancelled despite the provisions of Section 58. And the members of the company who have not agreed to contribute to the asset of the company in the event of the company being wound up cease to be members of the company.
Okay, good. So the 9.2, as I said, is telling us the practical procedure of how you actually achieve this conversion. The 9.1 prescribe the requirements, the conditions, which must be fulfilled. The fact that you must have no unpaid liability on your shares. You must be prepared to surrender your shares for it to be cancelled without you demanding any payment from the company. You must also sign or agree in writing that you agree with the conversion. So the company secretary and one director is supposed to swear, make a solemn declaration, so that is swearing, in the form of statutory declaration, that the things that we have seen under 9.2, the conditions have all been satisfied. Because the statement they are making is a statement under oath, the registrar of companies will accept it and proceed to issue a new certificate of incorporation, reflecting the fact that the company which was previously limited by shares is now a company limited by guarantee. So let us keep that in mind. Now, if you look at the 3, especially the C, we are told that if you are a member of the company and you are refusing to make undertaking regarding how much money you may want to contribute towards the assets of the company in the event of winding up, then when the conversion is being done and it is actually certified by the issuance of the new certificate of incorporation, you cease to be a member because you have not made undertaking in terms of how much you are prepared to contribute to the assets of the company in the event of a winding up. So let us keep that in mind. Let's look at subsection 4.9.4.
Okay. So 9.4, except in accordance with subsection 4 of section 21, the company shall not change the name under which the company was registered before the conversion.
Okay. Now, later on, when we are discussing the names of a company under section 21, it is possible for a company to change its name. However, where a company which was previously Company Limited by shares is being converted to Company Limited by guarantee, it does not warrant a change in name before the conversion can be actualized. And that is what 9.4 is telling us. Let's look at 5.
Okay, 5. The omission of words PLC, Public Liability Company, or Limited, which is Private Company Limited, as the last words of the name of the company after conversion shall not be regarded as a change of name.
Okay, good. Now, if you go to section 21, when we are discussing the names of the companies, you'll notice that the current Companies Act 992 has made some innovation, that is introduced new things. And one of the new things it has introduced is the suffix, that is the ending of the names of a company. What do you see over there? So if you later on discussing 21, you notice that if you have a private company limited by shares, you're supposed to have the word LTD at the end. And if you have a public company limited by shares, you're supposed to have the PLC at the end. Now, if you had any of this and you have gone through conversion to become company limited by guarantee, then 9.5 is telling us that, yes, because you are limited by guarantee, you have to do what is required of a limited by guarantee company. If you go to section 21, okay, you go to 21, subsection C, the last words of the names of company limited by guarantee shall be limited by guarantee, abbreviation LBG. LBG. So you, instead of having PLC or LTD, you are now going to have LBG at the end of that company limited by guarantee. So let us keep that in mind. Okay, so let's move on to subsection 6.
Okay. Subsection 6. If the registrar is of the opinion that the name under which the company is registered will be misleading or undesirable on its conversion to a company limited by guarantee, the registrar shall, in accordance with subsection 6 of section 21, direct the company to change its name and shall not issue a new certificate of incorporation until the direction has been complied with or cancelled in accordance with that subsection.
Okay, so that is pretty straightforward. Just to say that, yes, when you have gone through conversion from limited by shares to guarantee, you have to drop the names PLC, LTD, and then add LGB, limited by guarantee, at the end. However, where having done all that, the name of the company still appears not fit for purpose and is rather misleading, or it will bring some confusion. In the judgment of the Registrar of Companies, if that needs to be corrected, then it will give a directive that they should bring a new name in order to address any such confusion. And we go to section 21, subsection 6, the registrar of companies has the power when it makes a judgment that, or comes to a decision that a proposed name is undesirable, to ask the company to change the name. Yes, subsection 7.
Okay, subsection 7. Until a new certificate of incorporation. Okay, so sorry, I wanted to ask a question on the subsection 6.
Okay.
Okay, so my difficulty is the registrar of company already has the name of the company in their system. And per the preceding section that you read, they are not supposed to change the name. So at what point in time would a name that is already in their system, they already certified with regard to company limited by shares, which they was already prevailing in their system. At what point in time would it be is it
undesirable?
Unreasonable?
Okay. Okay.
Undesirable?
Good. So let's suppose that. Let's give this example that you have let's say multi-credit savings and loans PLC. Okay. And you decide to convert it to Limited by guarantee. So you drop the PLC and now you put the LGB there. Now we know that Limited by guarantee is not supposed to do profit-making business for it to be shared by members, except in furtherance of its objects. Now, if you say multi-credit savings and loans limited by guarantee, it will still suggest some confusion in the minds of the public, because the public will still think that it is the same, if you like, savings and loans company doing business for profit and so on and so forth. So the emphasis is not so much about what the name originally was, but having undergone conversion, you are taking on a new character, the character of you are not running for profit to share the profit for the members. You are limited by guarantee. And if you make profit at all, the profit is supposed to be in furtherance of the objects of the company. And for that matter, if the name which the company will have upon the conversion and after dropping the PLC and the LTD, if it will still be misleading or undesirable, then the registrar of the company is empowered by law to direct that they make the changes. I don't know, Mr. J,
Okay,
if that assists you.
Yes, I'm okay now.
Good. Okay, so let's move on to subsection 7.
7. Okay. Until a new certificate of incorporation is issued under subsection 2, neither the surrender of the shares of the company nor the agreement to contribute to the assets of the company in the event of the company being wound up shall take effect.
Okay. Good. So, because you notice later on when we are discussing section 15, effect of the certificate of incorporation, like certificate of incorporation. When we are discussing 15, you notice that certificate of incorporation marks the birth of the company. And if you have gone through conversion and a new certificate is supposed to be issued to signify the birth, and that has actually not occurred, then the agreement you made that in the event of the company being wound up, you are prepared to contribute so much, that will not take effect, because that company which you have made undertaking to contribute toward its assets in the event of its being wound up is not in existence. is not in existence as a company limited by guarantee because the new certificate of incorporation has not been issued. Let's look at the 9.8.
Okay, so the 9.8, the conversion of a company pursuant to this section shall not A, affect the rights or obligations of the company except as mentioned in this section, or render defective any legal proceedings by or against the company.
Okay, good. So let's suppose that you did a business. You did a business with the company when it was limited by shares. The company is supposed to pay you. It has not paid you. So you have a claim against the company. And then the company undergoes conversion to become limited by guarantee. Section 9.8 is saying that the mere fact that it has undergone conversion will not bring an end to your claim against it for the business that you did with it. In the same vein, where there were pending proceedings, either by the company against someone or someone against the company, should the company undergo conversion to become limited by guarantee, the conversion is not going to affect the ongoing proceedings. Good. So we are moving to another interesting concept of company law, because as you appreciate, we are still looking at, if you like, preliminary matters towards registration or formation or incorporation of the company. If you want to register a company, you need to decide what type of company do you want to register. And that is why we discussed section 7. You see the various types of what company. And then the 8 and 9 just gave us the idea that if you, for example, registered as a company limited by shares, it's possible for you to change to become something else. So when we are trying to register a company, we may need to make all these choices in terms of what type of company. That is why we've seen that. Now we are going to look at those who will make the various arrangements to enable the company to be registered, enable the company to be formed. And we call them promoters. We call them promoters. So let us look at section 10.
Duties of promoters. Section 10, subsection 1. A person who is or has been engaged or interested in the formation of a company is a promoter that company.
Good. So this is the definition of a promoter. We are not talking about boxing promotion. Remember, this man, is he alive? Duncan. Do you remember Duncan? You don't remember Duncan, a famous boxing promoter? Yes, okay. So we are not talking about boxing promotion. We are talking about promotion of company. So if we look at the definition, very interesting, especially section 10(1) and 2, that a promoter is a person who has been engaged or who is engaged or interested in information of a company. So if you are interested in information of a company, or if you're engaged in information of a company, you are a promoter of that particular company. And let's remember that you are a promoter in respect of a particular company. There's nothing like generic promoter, like you are a promoter at large. No. And that is why if you look at the provision, 10(1) says that a person who is or has been engaged or interested in the formation of a company is a promoter of that company. So you are a promoter in relation to a particular company, you help in bringing it about. So if you are saying you're a promoter of a company, you cannot point to the particular company you engage in or interested in information, then you are not a promoter. So let us keep that in mind. But some people may be engaged in information of a company, and yet they will not be regarded as a promoter. So let us keep that in mind. The general understanding of a promoter is that a person who is or who has been engaged or interested in information of a company. Nevertheless, it is also possible that some people might have done this, and the law is saying that they should not be treated as what? As promoters. So let's look at the section 10, subsection 2. Dauda. Yeah, ask your question.
Hello.
Yes, go ahead.
Yes, please, Doc. If I have gotten you said that a promoter is a person who is engaged in one particular company, but not two companies. Now, my question is this: can one person act as a promoter to different type of companies in at various circumstances?
Can one person do what? Please, can you put the TV or the radio off?
I'm saying that.
Do you have a radio or TV on?
Yes, please.
Yeah, please, let it be off.
Yes, sir. What I'm saying is that
So
if I have,
you say one just to listen to the TV. How can you be listening to a lecture and then you're watching TV?
I have lowered it, sir.
Okay. All right, go ahead.
Yes, sir. My question is, if I have heard you right, you said a promoter is a person who is or is engaged in the formation of a company, and you also added that a promoter is always a promoter to one particular company. And my question is this: can one person act as a promoter to different type of companies at the same time? Maybe, Doc, you have a company and I am a promoter.
Yeah, I understand you. Yes, it's possible. So, I understand you. You're a promoter in relation to a particular company, but the particular company does not mean that you cannot promote more than one company. You can even be a promoter of million companies, so long as you engage or you're interested in the information of those companies. But what I wanted to warn against is that you cannot say you are just a promoter and then we cannot point to a particular company in respect of which you did your promotion. I don't know if that assists you.
Okay, so Doc.
Okay.
Yes.
Please, please, Doc, I also want to be clear here. So if I have identified some business opportunity somewhere, and then I see it very important to sort of convince people to come together to form a company to be able to take advantage of that opportunity, it means I'm a promoter. Is that the case?
Promoter, yes.
Okay.
You're a promoter, yes. Good. But as I said, some people may do all that a promoter will do, but because they are doing that in professional capacity, they are not treated as a promoter. So if you look at subsection 2 of 10, a person acting in professional capacity for persons engaged in procuring information of a company is not a promoter of that company. So let's say that you're a lawyer, you are a chartered accountant, you are an auditor, and you provide a service, paperwork or some other things in relation to the setting up of a company. Now, what you have done, you did it in professional capacity, and for that matter, you will not be reckoned or you will not be treated as a promoter of that company. So that is what section 10.2 is telling us. Now let us look at the obligations. Yeah.
Yes, sir. I wanted to have this question. You said a company limited by guarantee, a company, a private company can change to company limited by guarantee. Is it also possible?
I said company limited by shares.
Yeah.
Can change to
company limited by shares. Can change to company limited by guarantee.
Yes.
Is it also possible that a company set up for limited by guarantee will also change to company limited by shares?
Or the either way.
The other way around.
The other way around.
Yes, sir. Assuming the company limited by guarantee, they always be on the social activities. And
okay.
If they have now seem to be having an opportunity to do a rare business, then they want to move that company limited by guarantee to proper company making profit. Is it possible?
Yeah, and then in that case, you just have to liquidate this one and then incorporate a new company limited by shares. You see,
is it that?
The reason why we are more interested in limited company by share to guarantee rather than guarantee to shares is that in the case of company limited by guarantee, as we know, there are no shares, right? There are no shares.
Yes, please.
So people need to make commitments in the form of undertaking regarding how much they are prepared to contribute towards the assets and liabilities of the company in the event of being wind up. And that is why we are more concerned about moving from shares to guarantee. But if you want to, if you have a company limited by guarantee and then you want to do shares, you need properly, you may need to wind up this company limited by guarantee and then incorporate a new one, because shares are supposed to bring money into the company. And from what you said, if the company limited by guarantee is doing very well already, then there's no need for capital injection, isn't it? So you don't really need like the shares. But if the shares are meant to enable you to share the profits, then you need to wind up the existing company limited by guarantee and then incorporate a company limited by shares for that purpose.
Yes, sir. Normally, the company name, you cannot have two companies having the same name. So assuming the company limited by guarantee was into maybe a clinic or a health sector, and now they want it to be a clinic or a school, like a school, and they want it to be a profit-making organization. And so they want the same name to be incorporated. Is it possible?
No, but it will be possible because don't forget, if it's limited by share, we're going to add the LTD or the PLC, depending upon the membership. So if, for example, you had something like a clinic like, what clinic comes to mind? SYZ clinic, right? Limited by guarantee. Now you want it to become, you want to use the same name. If you put the LTD or the PLC there, it becomes something different. Okay. They are not the same. They are, so long as the company limited by guarantee will not be in existence. If it's going to be in existence, then the registrar may say that it will be misleading. But if it's going to be liquidated or wind up so that it's no longer in operation, it's no longer in existence, the name will be available and it will not be misleading. So let's look at the duties
Thank you,
of, okay, duties of promoters in terms of section 10.3.
Okay, so section 10.3, the promoter shall, until the formation of a company is complete and the working capital of the company has been raised, A, stand in a fiduciary relationship to the company, observe utmost good faith towards the company in a transaction with the company or on behalf of the company, and compensate the company for any loss suffered by the company by reason of the failure of the promoter to observe good faith.
Okay, good. Now, this is very interesting, and there are a lot of old English cases which we also meet when we are discussing pre-incorporation contracts. Now, if you want to set up a company, from the examples that a number of you have given, usually there will be either an opportunity you want to take advantage of, for which reason you want to get a company form and so on. So, going to form the company, you may need to even buy land in anticipation of the company that you are going to register. You may need to get machinery, you may need to get certain things and all that. Now, the company is not in existence yet. Remember, because if the company were to be in existence, we will have the board of directors and other employees doing all manner of things. So you, the promoter, you are going to stand in and do a lot of things for and on behalf of the company which is yet to be formed. Now, there's that risk that you may take advantage of your situation to the detriment of the company. For example, you may incur certain unreasonable expenses even for your own benefits and try to pass it to the company so that when the company is formed, you take the money from the company and all that. And for that matter, the law is that if you're a promoter, from the time of the formation of the company, that is when it is incorporated, until the time that the working capital has actually been raised. The law says that you stand in a fiduciary relationship. Fiduciary relationship, if you remember from your commercial law, means that you stand in a position of trust and confidence. It is a position in which utmost good faith is required of you. That is to say that you'll be honest, you'll be transparent, you will not make any secret profits, and so on, to the detriment of the company. And for that matter, if you let the company incur any losses as a result of the breach of your fiduciary obligation because you failed to be honest or you decided to shortchange the company and all that, the law is that you have to compensate the company for those losses that you have occasioned to the company by your failure to actually observe utmost good faith, to be honest in your dealing with the company. So let us keep that in mind. We'll be discussing Kellner and Buster when we are talking about pre-incorporation contract, which is also part of the things that promoters will do. Because pre-incorporation contract, as you notice, as the name suggests, pre means before, and incorporation means the registration of the company. So all contracts and transactions which are made before the company is incorporated are pre-incorporation, and they are done by the promoter. The promoter can take advantage of the yet to be formed company, and that is why the law provide this protection for the company as against any possible abuse by the promoter. So let us keep that in mind. Okay, so let's take subsection 4.
Okay, subsection 4. A promoter that acquires property or information in circumstances in which it was the duty of the promoter as a fiduciary to acquire the property or information on behalf of the company shall account to the company for the property or information and for the profit which the promoter may have made from the use of that property or information.
Okay, so because you're a fiduciary, if you exploit your peculiar position in relation to the company and you acquire profit or you come across a certain information because you are working as a promoter of the company, and for example, you decide to use that information for your own benefits. Now, later on, when the company is formed, you will be held or you'll be called to account. You'll be held accountable for all properties, for all corporate opportunities or information which came your way as you were working as a promoter for that company, which was yet to be formed, and now it is formed. Now, later on, when we are discussing directors in the second semester, you appreciate that the duties of directors in some respects are the same as the duties of promoters, because directors are also seen as fiduciaries. They are supposed to exhibit utmost good faith. They are supposed to be honest. They are supposed to avoid making secret profits. They are supposed to account for secret profits made and so on, and avoid conflict of interest. So all those things which are applicable to directors, we are also seeing them here as being applicable to promoters, because mind you, promoters more or less are playing the same role as directors will play when the company is eventually formed. Now, let us look at how the law regulates transactions which offend conflict of interest, if you like, by a promoter, or transaction in which a promoter has violated his or her fiduciary obligations. So let's look at the subsection 5.
So I have some small question.
Okay.
So from section 3 and then 4, it's as if the promoter is
It means subsection 3.
And subsection 3. Okay,
3?
the promoter shall onto the yes, subsection 3, sorry.
Yeah.
And subsection 4, it's as if the promoter and the company pending incorporation is in a form of agent principal relationship, but it looks as if only the liabilities of all the liabilities are against the promoter. But is there not any benefit to the promoter with respect to he helping the company to make profit, or maybe acquire property or information for the property that he has made profit out of?
Okay, so the name of the game is transparency and disclosure. Once the promoter is transparent to the company when it is eventually formed and discloses all that it came his way as he was working for the company, there is no problem. And that is what we are going to look at in terms of subsection 5. Okay, so the answer to your question lies in subsection 5. So let's take subsection 5.
Okay. Subsection 5. A transaction between a promoter and the company may be rescinded by the company unless after full disclosure of the material facts known to the promoter, the transaction has been entered into or ratified on behalf of the company. A, by the board of directors of the company, if all the directors of the company are independent of the promoter, by all the members of the company, or by the company at a general meeting at which neither the promoter nor the holders of the shares in which the promoter is beneficially interested have voted on the resolution to enter into or ratify that transaction.
Good. Yeah, so if we look at the 5, the term 5, as I said, and in further in answer to your question, that yes, there could be some gains by the promoter as he works for the yet to be formed company. And as they say it in Akan, I don't know how to better render it in the Queen's language, that you know that adage?
Yes.
Good. So the promoter is the one trying to bring about this company and all that. Certainly, some goodies may come his way or her way. However, those goodies or those benefits are not to be enjoyed immediately, because 10.5 is saying that if there's any transaction between you, the promoter, and the company, that transaction can be rescinded, that it can be set aside by the company. So let's suppose that you had 2 acres of land and you sold 1 acre to the company. And so the company is owing you. When the company is formed, it's supposed to pay that debt, right? Now, section 10.5 is saying that the company has the right, upon coming into existence, to rescind, that is to cancel any such transaction, for example. But if there has been a full disclosure, okay, if there have been full disclosure of all the circumstances to the promoter, I mean, like that is the promoter has laid everything bare and all that, the company can decide that yes, this thing which the promoter did before the company was formed, we like it, we want it to remain, so we are going to adopt it, despite the fact that the promoter stands to benefit from it. Now, that approval, that is a ratification, can be done either by the board of the directors, completely independent of the promoter. That is, say that the promoter has not nominated any of the board of directors and so on, or all the members, or a general meeting, and then the promoter will have to excuse himself, so that the company, without the involvement of the promoter, will independently and objectively make up its mind as whether it wants the transaction which was concluded between its and the promoter to stand or not to stand. Now there's this old case, which I would like you to look at, the case of Gladstone and Barnes. Let me put it in the chat for you. Gladstone and Barnes. Gladstone. I don't know if you can see what I'm writing. Can you see? Gladstone.
So we can see.
You can see. Okay, maybe
Yes.
when I hit
No,
the
sir.
send, maybe it will come. That's maybe when I hit the send, it will come. So don't worry. This one. Did it come?
Yes, sir.
Okay. Let me get the site. I'll get a citation for you. But what happened in the Gladstone and Stan was that a syndicate was formed to raise money and buy a certain property and resell it to a company or any other purchaser. And the facts indicate further that the fundraise was to be in the names of trustees who were to form a company to which they should resell the property. So the trustee were also to be directors of the new company to be formed. The trustees purchased a property and formed a company. They then resold the property to the company for a huge profit, of which they were the first and at the time, the only directors. So they issued prospectus soliciting for shares, but they failed to disclose the profit made. Now, later on, the company went into liquidation, and then the liquidator went through the books and sued for the profit made by them in the transaction. And when the matter traveled all the way to the English House of Laws, the court was of the view that the trustees were promoters of the company. And for that matter, they ought to have disclosed to the company the profit which they made. And the court made the further point that even though the company could not rescind the contract, that, of course, I mean, that is, our law here. Our law here, is a bit of a modification to the common law, because under common law, the case of a Kellner and Buster will be told that the newborn in Sensoline, the court will tell us that when a company is not incorporated, it cannot have an agent. An unincorporated company cannot have what? An agent. That is the common law orthodox position. But that has been modified under Ghanaian law. And that is why section 10.5, for example, even saying that the company can ratify transaction which was made by
the promoter.
The company can modify transaction. The company can modify a transaction which was made before before the company was actually formed. Now, the promoter, in terms of 10.5, is being seen as an agent. Because if you remember your agency law, a principal-agent relationship, agent does something without prior authorization, and subsequently the principal will ratify it. So The common law does not recognize that an unincorporated company can be a principal, right? For which reason the promoter will be like the agent. And that was the situation in the Glasson and Barnes, and also the case of a Kellner and Buster. But as I said, in Ghana, if you read Gower's commentary in respect of the predecessor provision of section 10.5, there has been some modification, and that is why we have the provisions that we have currently before us. So let us take note of that. Let's take.
Okay, so sir.
Yeah.
So sorry, short one. So from section 10.
Yes.
3, 4 to 5. So what I am I've understood is that being a promoter is somehow risky. Is that not the case?
It is. It's not somehow. It's risky. It's risky.
Okay.
But if you are acting in good faith, it's okay. You can actually play safe. You know, in this world, if you're doing anything, if you have a clear conscience, you are not afraid. But if you don't have clear conscience, then everything is dangerous, isn't it?
Okay, yeah.
So let's take section 10.6. You'll be finishing with subsection 7 and we'll continue another time. Yes. Reader.
Sorry, a period of limitation shall not apply to proceedings brought by a company to enforce a right under this section.
Good. Now, this is very important. If you remember, your Ghana legal system and also tort and contract, you know what we call like the limitations decree or the law on limitations. Certain types of cases or causes of action, a time frame are prescribed so that after expiry of certain time frame, you will not be allowed to bring the case and so on and so forth. Now, in the case of breach of fiduciary obligation by a promoter, there is no time limit. Even if it will take 100 years for the company to become aware that before it was incorporated, the promoter engaged in a certain questionable transaction to the detriment of the interest of the company can go to court and get a remedy against the promoter. So that is very, very important. There's no time limit. And sometimes what the promoter did may even be discovered. Just look at the Glasson and Barnes case. After a long time, when the company was liquidated and a liquidator was appointed, the liquidator was going through the books and got to know that this transaction was done at the pre-incorporation stage, and this malfeasance went on. But the good thing is that if you look at subsection 7, where a case is brought in court, the court has the power to relieve the promoter in whole or in part in whole or in part. Okay. From liability, which the court consider to be appropriate. In other words, if the company, for example, has taken the promoter to court, the court can look at all the circumstances and say that, well, this thing took place 5 years, 10 years, 20 years ago, and having regard to how the company has even benefited or been very successful, it is not fair, it is not just, it is not equitable for the company to be pursuing this against this promoter. And for that matter, we are going to relieve the promoter from effect of this transaction, the company would like to pursue it against him and so on. So the takeaway under 10.7 is that the court has the power, the discretion, having regard to the equities of the situation, to make the necessary orders which will ensure justice. So this will mark the end of the discussion for tonight. Unless there are questions, I will continue tomorrow. Okay, good night.
Hello, sir. Sir,
Yes.
please, can we get all the recordings, please?
Yes,
Begin
I
from
try uploading them, but where I am, the internet is a bit slow. So when it's uploaded, I will send you the link. When you click on it, you'll be able to access it. Okay.
All right, sir.
All right. Thank you.
Thank you.